We will be inviting Ms. Lim Kim Hong, sole proprietor of Kim & Co., with 32 years of experience in the legal field, to shed some light on this matter. Ms. Lim Kim Hong was admitted to the role of advocates and solicitors at Supreme Court in 1988. After working with various legal experts, Ms. Lim set up a boutique law firm of her own in 2004, assisting her clients from litigation to general solicitors' work. Feel free to type your questions on this sharing in the chat function beside the live video. Due to time constraints, the speakers may either take 1 to 2 selected questions or not take any questions at all. Ms. Lim Kim Hong, please.
Hi everyone. Good afternoon to everyone. Now, I'm Ms. Lim Kim Hong, and I am the sole proprietor of Kim & Co. Otherwise, I'm known as Kim to all my friends. Now, Kim & Co. is a small boutique firm, and we deal with many areas of law, which includes general litigation, conveyancing, and corporate matters. If you wish to know more about our services, feel free to go into our website, which is at www.kim-co.com.sg. Now, as per my humble introduction, I have been a lawyer for 33 years, and one of the areas of law which I deal with on a daily basis is matrimonial matters. And of course, part and parcel of that is the question of how would matrimonial matters deal with CPF issues. Now, before we proceed further, I would just wish to give a synopsis or an outline of what is CPF. And for today's purposes, we will be dealing with personal status changes which will affect CPF monies and assets. Now, the first status of change is a divorce. What happens to CPF monies when CPF member gets a divorce? And what happens to the properties which are purchased using CPF monies? And lastly, what happens to CPF nominations which were made by the members before the divorce? Are they revoked or do they continue to be valid? The second form of personal change which I will be dealing with is the loss of mental capacity of a CPF member. Now, the usual questions would be, what happens when a person loses his or her mental capacity? What happens to the CPF monies? And more importantly, can those CPF monies be withdrawn for purposes of the member? The last personal change which I will be dealing with would be if a CPF member becomes a bankrupt. Now, what will then happen to the CPF monies of the bankrupt? Will it be protected from bankruptcy proceedings, or will it not be by such? Now, I'm sure everyone knows what CPF is, but of course, I would still need to give a general purview of what it is. Now, we know that in Singapore, CPF is a mandatory social security savings scheme. It is funded by the employer and employee contributions of all members who are gainfully employed. Now, the purpose of a CPF in Singapore is to prepare Singaporeans as well as permanent residents for retirement and also to meet other needs. These other needs are, for example, healthcare, where we have MediSave as well as MediShield, and there is also property needs, which is covered by the CPF housing schemes. And we do, of course, know that generally CPF members may withdraw their funds only after they attain 55 years of age. Now, as a result of employment, CPF monies are likely to form a significant portion of a Singaporean's or a PR's assets. So the topic for today, which I will be dealing with, would be what happens when a CPF member undergoes changes in personal status. A divorce. 2, a loss of mental capacity. And 3, bankruptcy. Now, for the first topic, which is for a divorce, we will deal with what happens when the CPF member gets a divorce and what happens to the CPF monies. Also, what happens to the properties which were purchased using the CPF monies. And also what happens to the CPF investments which were made also using the CPF monies. Last but not least, we will know what happens to CPF nominations which were made before the divorce. Now, a divorce is a legal process of terminating a marital union between a husband and wife. It is a dissolution of a marriage. Now, in Singapore, a divorce is a legal proceedings that takes place in a 2-stage process. The first stage is to grant the divorce on a summary basis, and it is known as an interim judgment. Once an interim judgment is obtained, then the court will deal with all the ancillary issues. These ancillary issues will include the children issues, which are custody, care, and control of the children, as well as the maintenance for the children. It will also deal with the maintenance for the wife. And lastly, the ancillary issue that we are concerned about today is the division of matrimonial assets. The reason for this is that CPF monies is a form of matrimonial asset, which is to be divided upon the dissolution of a marriage. Now, in Singapore, the legislation which governs a divorce is encapsulated in the Women's Charter. Now, there is a definition of what comprises matrimonial assets in the Women's Charter. And it is found at section 112, subsection 10 of the Women's Charter. And it is defined to be any asset acquired before the marriage by one party or both parties to the marriage, which is ordinarily used or enjoyed by both parties or one or more of their children while the parties are residing together. 2, it can also be any asset acquired before the marriage by one party or both parties to the marriage, which has been substantially employed and improved during the marriage by the other party or by both the parties to the marriage. 3rd, it can also be any other asset of any nature acquired during the marriage by one party or both parties to the marriage. And lastly, it is not an asset which is not a matrimonial home that has been acquired by one party at any time by gift or inheritance, which has not been substantially improved during the marriage by the other party or by both parties to the marriage. Now, under section 112, subsection 1 of the Women's Charter, the court has the power to divide matrimonial assets as it thinks fit, just, and equitable. Now, for CPF-related matrimonial assets, what are we concerned about? Firstly, we are concerned about the matrimonial home. That is where the parties live in the course of their marriage. And as we know, CPF monies can be utilized towards the purchase of a matrimonial home. So, a matrimonial home which is purchased using CPF monies by either one or both parties will be subject to division by the court. The second form is CPF monies acquired during course of the marriage. Now, we all know that when we are gainfully employed, the employer as well as the employee contributions will go into 3 forms of accounts with the CPF board. The first is the ordinary account, the second is the special account, and thirdly, the MediSave account. All these 3 accounts and the CPF monies contained in these accounts will be part of matrimonial assets subject to division by the court. And lastly, CPF monies may be used by the CPF member towards investments. And such investments which are acquired during the course of the marriage will also form a matrimonial asset subject to the division by the court. Now, in dealing with CPF monies, the court may order 2 different types of orders. One is a transfer order, where there is a transfer of money from a CPF member's account to the spouse's CPF account. 2, we have the charging order, which is the payment of CPF monies to the ex-spouse, which is usually given when the ex-spouse is not a citizen or a permanent resident of Singapore. Now, before I move further, I wish to clarify that some parties have questioned what happens to the CPF account monies prior to the marriage. Will they be part of matrimonial asset subject to division by the court? Now, the simple answer is no. As long as you can dissect and take apart the monies which were acquired before and during the marriage, then CPF monies accumulated in the accounts prior to the marriage will not form matrimonial assets subject to division by the court. There is, however, one exception. The exception is where those monies were then used by the CPF members towards either the acquisition of a matrimonial home or towards investments which are made during the course of the marriage, whereby that will change the flavor of the CPF monies. Now, we are also concerned with what happens to CPF nominations which are made before the divorce. Question: will such nominations be revoked upon a divorce? Now, the simple answer is that a divorce does not revoke, I repeat, it does not revoke a CPF nomination. This means that if you have made a nomination with the CPF board prior to your divorce, it will continue to subsist even after the divorce. As such, it is very important for CPF members to take note that they should review their CPF nominations after a divorce. Now, the second personal status which I'm dealing with would be the loss of mental capacity of a CPF member. Now, when does a person lose the mental capacity? 2, what happens to the CPF monies of a person who has lost mental capacity? And thirdly, can the CPF monies of such a person be withdrawn? Now, the legislation in Singapore which deals with mental capacity is the Mental Capacity Act. Section 4 of the Mental Capacity Act defines what is a loss of mental capacity. Now, a person lacks mental capacity if at the material time he is unable to make a decision for himself or herself in relation to the matter because of an impairment or disturbance in the functioning of the mind or brain. Now, for purposes of the CPF Act, a person lacks mental capacity where the board is satisfied that such lack of capacity is likely to be permanent. And that is found in Section 2, subsection 5 of the Central Provident Fund Act. Now, can a person who does not have mental capacity handle his own CPF monies? Now, the short answer is no. And therefore, a lot of people are now making plans and steps towards ensuring that there is sufficient safeguard in the event that he or she loses his mental capacity. Now, in the past, when a person loses mental capacity, the next of kin will have to run to court to get a court order to appoint a deputy to the estate of that person to manage the affairs of the person who has lost the mental capacity. But after the introduction of the lasting power of attorney, it is now possible for any person who has yet to lose their mental capacity to appoint a third party to manage his or her affairs should he or she loses the mental capacity. And this person to be appointed is known as the donee. So under Section 2, subsection 3 of the CPF Act, there are 2 categories of persons who can handle the CPF monies of a person who lacks mental capacity. Firstly, it will be deputy by way of an order of court, or 2, it will be the donee who is appointed by the person prior to the loss of his mental capacity. Now, can the CPF monies of a mentally incapacitated CPF member be withdrawn? Now, the short answer is yes, except for the fact that the member is not allowed to withdraw its MediSave account monies. Now, even though CPF monies may be withdrawn, it must be subject to CPF Board's authority and approval. Now, such authority would include the following. 1, where the CPF member is entitled to withdraw the monies reaching the age of 55. 2, on the basis that the member is mentally incapacitated from continuing in any employment. Or 3, It is just that the member lacks mental capacity. So the member will then not be able to use the CPF monies, and the nominated donee or deputy will then apply to the court or to the board as appropriate. The board may give certain directions. Such directions would include sums to be set aside or topped up in retirement account where the withdrawal is sought on the basis of incapacity. And as I said earlier, any withdrawals of monies with the CPF of members who lack mental capacity may be subject to other terms and conditions of the CPF board. Now, the next personal status which we deal with is bankruptcy. Are CPF monies protected from bankruptcy proceedings? Now, the short answer is yes. Generally, CPF monies, which includes the profits of CPF investments, shall not pass to the official assignee or creditors upon bankruptcy. CPF monies can also be withdrawn if the member is entitled to do so and does not owe monies to the government. But one point to take note is that when the investments or cash balances with the CPF accounts are withdrawn, then those monies will no longer be protected from the official assignee and or creditors. Now, that would be the talk which I have prepared for today, and I will deal with some of the questions which have been given. Now, the first question, if I may repeat, from Kenneth Cole is, are prenuptial agreements legal to prevent the spouse from getting a share of the CPF monies and other assets? Now, as per what I have illustrated earlier when I dealt with matrimonial assets, the court makes the decision in relation to division of matrimonial assets pursuant to Section 112 of the Women's Charter. So the final decision on how CPF monies and other assets are to be divided would be determined by the court. A prenuptial agreement may reflect what the parties wish to apply their minds to, but that prenuptial agreement is not binding to the court. At the end of the day, Section 112 will decide and determine the issue. Now, the next question is, what basis the court decides the proportion of matrimonial assets division between the spouses? Now, this actually has nothing to do with CPF issue, but since this is a question that has been raised, I would inform everyone concerned that there is a landmark case of ANJ and ANK, and in that case, the court has come up with a broad brush approach on how matrimonial assets are to be divided. Now, that broad brush approach will include determining the direct contributions of the parties as well as the indirect contributions of the parties. So what the court does is to pool together all the assets of the parties, By assets, I mean matrimonial assets. So the matrimonial assets to be pooled together would be assets in their sole names as well as assets in their joint names. After those assets are pooled together, the court will then decide on the percentage of the parties based on direct and indirect contributions, and finally determine what is a fair, just, and equitable division between the parties. Now, there is a question here, which is, if both parties have reached retirement age, will the CPF money used for housing need to be divided according to the court order? Now, if both parties have reached retirement, the question would still be whether the CPF monies utilized for the purchase of the matrimonial home is still subject to such purchase. If that is so, then the court is able to make a division of those CPF monies. But once the division is made, the CPF monies which are divided need not go back to the accounts of the respective members, since both parties have already reached their retirement age. That would be all for today. If you have any further questions which you require further clarification, feel free to contact me at my law website, which had been given earlier. Thank you, everyone.